Morning.
Morning, Your Honor. Jim Kurji, PA 320 on behalf of the plaintiff, Bill Sanford.
Welcome back to Courtroom, where today's case feels more like a property law thriller than a simple landlord-tenant spat. At the center, Judge Simpson presiding over a clash between landlord and tenant that turns on one crucial document, the certificate of compliance. Without it, a landlord can't legally collect rent. Yet here we are watching both sides wrestle over thousands of dollars, water bills, and possession rights. This is not just about whether Susie Norman pays up or stays put. It's about the legal backbone of renting itself. Judge Simpson wastes no time pushing straight into the conflict, and the tension is thick. We're talking job offers in Seattle, inspection delays, accusations of unannounced visits, and even escrow fights that could decide who walks away with thousands. Stick around because this case has everything: sharp questioning, landlord missteps, and a tenant who won't be cornered easily.
Your name? Susie Norman.
All right. And where are we on this case? Well, good.
So, Your Honor, I submitted a motion for summary disposition, and that there's no genuine issue back here on this non-payment.
Did you get a copy?
I did via email.
Are you going to respond to that?
I have my response was a case that I had opened. It's supposed to go under Judge Barr. That was my response. And I came to the courthouse and wanted to file what I could. And the girls said there was a note on my case that said, Judge Barr, I guess Judge Barr, I don't know. Someone wrote a note that you were going to look at that today and use that as my
Okay, great.
Counter,
Well,
since the cases were of the same people.
have you vacated the premises or no?
I have not. As you know, I have my job offer in Seattle.
The judge gets right to the heart of the matter. Has Susie actually left the property? Her answer, a flat no, shifts the entire dynamic. If she's still in possession, the landlord needs that certificate of compliance to enforce rent claims. And guess what? He doesn't have one. This is a nightmare scenario for landlords because without compliance, rent demands collapse in court. Susie, meanwhile, positions herself as cooperative, mentioning a job offer in Seattle, but insisting she must appear in person until the case resolves. The judge hears all of this and immediately begins poking holes in the landlord's legal position. For the audience, this moment is key. The law isn't just about whether you should pay, it's about whether the system allows the demand in the first place.
And I'm here because I'm still here in the city because I have to appear in person. So, and just trying to wrap this up.
So in regard to your motion for summary, why wouldn't I consider what she has filed in the other case as creating a genuine issue of material fact?
So, Your Honor, one moment. The crux of that case is that her property didn't have a certificate of occupancy. That was just brought to light recently as, I guess, a separate claim. Rent was ordered to be placed on escrow by the court. Rent has not been, only 1 month of 3 months rent has been placed on escrow with the court. In my motion.
Right, but if there's no certificate, if there's no COC, how does your client even charge rent?
This is the legal brick wall. The landlord's attorney tries to pivot, saying they're only after possession, not money damages. But Judge Simpson isn't letting go. If there's no certificate of compliance, how do you even justify demanding rent in the first place? This is one of those courtroom gotcha moments where the law leaves no wiggle room. Think of it like driving without a license. You might have a car, but you can't legally be on the road. Here, the landlord may have a lease, but without compliance, it's unenforceable. Susie's defense gains massive weight at this point. The judge forces the attorney to admit they have no legal theory to proceed under, and that's devastating.
So, Your Honor, my client has been in touch with the city of Pittsfield and has been arranging to get the COC.
The city of Ipsy?
Pittsfield Township.
Yep, okay, that's fine, but how does he charge rent if he doesn't have a COC?
So, Your Honor, this is not we're not claiming rent. We're not claiming money damages for rent. We're just claiming for the possession.
I don't know what that means.
This is not a claim for money damages. It's just a claim to return the property. At some point, some rent is due because Ms. Norman remains in possession of the property.
But there's no COC.
Your Honor, the COC expired in March of this year. According to my client, the city of Pittsfield has told him they're shorthanded on building inspectors. That's why he didn't receive a notice. He's been in touch with them to try and get the COC sorted out. The number of things pointed out on the violations of the other case are things such as a permit for electrical outlets.
The landlord's attorney claims they've been contacting the city, but Judge Simpson doesn't flinch. The certificate expired in March, and months later, nothing is resolved. Saying we've been trying isn't a defense in court. Think of how damning this looks. A landlord trying to push a tenant out while failing to maintain the most basic legal requirement. The violations weren't even about habitability, just technical code issues like outlet permits and water heater paperwork. Yet none of it excuses the lack of compliance. Simpson drills down hard. Without that certificate, rent can't be claimed, period. Notice how calm Susie stays here. She lets the judge do the heavy lifting. Strategic silence can be powerful.
Permit for a water heater. There's no complaints in that inspection report of items that are not working. It's items that are not up to code.
Is there anything under the Pittsfield ordinance that extends it?
Say again.
Is there anything under the Pittsfield ordinance that extends the COC?
Not that I'm aware of,
There isn't.
but I have no control over them administering their duties as far as issuing those.
Do you have the prior COC?
I don't, but I don't have it on me, Your Honor. But if you would like, Your Honor, I have a ledger based on the payments that were submitted in her other case.
Okay, but you have to get past the legal issue of how can if his certificate of compliance is expired, how does he charge rent?
Your Honor, so I believe that the rent being questioned would be the rent moving forward from the time in which that was brought to our attention. But that's correct, Your Honor.
From the time it's brought to your attention.
Yeah, from the time the issue's raised.
Pardon?
From the time the issue's raised, Your Honor. She signed the lease. She's made payments as if there were a COC. Turns out there's no COC. We're not asking for.
From May through today, how do you charge rent if there's no COC?
I believe my client's in a position where he can't charge rent, or that rent would be disputed.
That what?
That rent would be disputed, and it's being disputed in the other case she's raised.
Right.
Right.
I don't understand what you're saying. You filed a landlord tenant case seeking non-payment of rent. Right?
Seeking possession of the property for now.
Seeking non-payment of rent. Right?
Correct, John.
You can't, under what theory can your client charge rent?
This is the breaking point. The landlord's lawyer concedes they have no legal answer. When a judge asks, under what theory, and your response is silence, you've already lost ground. In fact, this is where Simpson practically hands the case back to Susie. The only option left is to pivot to a 30-day notice process. But that's damage control, not a winning strategy. Pay attention to the judge's tone. This isn't casual questioning. It's a controlled dismantling. Simpson is saying your case doesn't belong here, not under these facts. This should be a huge warning sign for landlords watching. If your paperwork isn't airtight, the courtroom is not forgiving. Audience question: do you think the attorney should have withdrawn earlier? Or is it smarter to fight until the judge corners you?
If he has no certificate of compliance.
Your Honor, I don't have a theory right now as to a legal theory as to how he can do that. I have,
Well, then how are you going to go forth on this case?
the other option, Your Honor, is to do.
We would all agree that in order to charge rent or to rent property in Pittsfield, you have to have a certificate of compliance, right? We're all in agreement on that. He has no certificate of compliance. So how does he charge rent?
So, Your Honor, I think the answer would be that he can't charge rent until he gets a certificate of compliance. Or see,
Okay. So it expired in March. The rent you're claiming she owes is for a period after March through today. And from that period after March into today, he doesn't have a certificate of compliance. So how does one evict?
so, Your Honor, we could go through with a 30-day notice, but my client has been undergoing efforts to obtain that COC. It's not as if he has just ignored the issue. He's made efforts to correct it, and he would like to correct it. The problem with correcting it right now is that Ms. Norman is in possession of the property, and he can't make repairs, or has attempted to make repairs and been told.
Has he attempted to make repairs?
That is,
I have tried to make repairs. There's been 4 times when I have sent a appointment to go over there, make repairs, and she has refused me to enter to make those repairs. So I can't make the repairs.
When is the township going over?
What's that?
When is the township coming in to inspect?
Well, they are claiming they're going to come back in November 2nd or something.
Then counsel, if that's the case, why am I hearing this now? You have no legal theory upon which you can proceed.
Judge Simpson shows visible frustration. Imagine being a judge and hearing a case that legally should not even be on your docket. The attorney admits the certificate issue was known at the last hearing, so why bring it again without a fix? Simpson calls it out. This is wasted court time. It's also a credibility hit for the landlord. Courts hate when lawyers stall or hedge. Here the judge even hints at merging the cases, treating Susie's claims as a counter. That's a tactical loss for the landlord, because now the narrative flips. Instead of chasing rent, they're defending why they shouldn't have asked in the first place. The atmosphere shifts. You can feel Simpson taking control and tightening the screws. Legal insight: once a judge sees you as unprepared, you're in a hole that's very hard to climb out of.
The other case is now my case. So I'm just going to consider it as a counter to this case. So why am I hearing it today if your client has no COC?
Your Honor, I heard it first at the last hearing, so I may have a moment to confer with my client.
Way.
That's what
We're allowing this. Yeah, stop. Right.
Thank you, Your Honor. We can agree to dismiss this at this time and move forward with under a different process as my client attempts to obtain a COC. The court feels that that's the best thing to do at this time.
I'm just trying to figure out how you're going to proceed. I think part of Ms. Norman's claim is that she's owed money.
So Ms. Norman has been in possession of the property the whole time under a lease agreement. Now, that lease agreement has an issue with the
Which he
COC.
cannot legally do because he doesn't have a COC.
So without more investigation into the COC and why that wasn't issued or what the issues are with the COC, I can't speak to the matter at this time. I've looked at the inspection report that was provided in the other case. And the items on the inspection report didn't appear to be items that would be interfering with the daily use of the premises.
You do understand this isn't about habitability.
Correct, Your Honor.
Well, they made an inspection and made this report, and they have another inspection lined up for the November 2nd. But if she won't let me go in to make repairs, I told the building department, because we're in the middle of an eviction, that I want to delay that till she lets me in. Will you make an order to?
Your Honor, I think he's saying until he believed he would get possession back and then finish the permitting of the boiler and whatever was on the inspection report.
This excuse doesn't fly. The landlord says they delayed repairs because they expected possession, but that's backwards. Possession can't happen until compliance is fixed, not the other way around. Judge Simpson immediately spots the circular logic. And here's where Susie pushes back. She accuses the landlord of popping up unannounced, cornering her about rent, and even flashing bills at her face. That's not just bad optics. It borders on harassment. No wonder she's resistant to letting him in. Think about the tension. A landlord who needs access to fix code violations, and a tenant who doesn't feel safe with him showing up unannounced. Simpson cuts through the noise. Just give me a date. It's classic judicial efficiency. For viewers, what would you do in Susie's shoes? Let the landlord in, risking pressure tactics, or hold the line until a neutral process is enforced?
When are you gonna let him in?
The problem with me letting him in, the first time, he comes over unannounced, and I've asked him not to do that. I've asked him to contact.
Okay, Ms.
me.
Norman, give me a date that you're gonna let him in.
He give you a date when he could come in and repair, or when? I'm sorry, I didn't hear you. My bad.
Isn't that what I said?
Is that what he said?
Yes. That's what I said.
I don't have a problem with him coming in. I have a problem with him cornering me off, asking me when I'm getting out of there when this case is ongoing. He's done that twice. That's why I have a police report on my other case, because he just popped up unannounced, asking me when I'm gonna pay the rent, flashing the water bill. I talked to Cindy at the Pittsfield Township every time we have a court date, and he has me paying it. He's suing me for the water bill. I just let them know that I will, if whatever the ruling is, I will let them know if I have to pay it or if I have to pay him and he's gonna pay it. I don't have, so that's the only problem. He comes unannounced and he starts asking me when I'm paying the rent, when I'm putting stuff in escrow, when I'm doing this, when I'm doing that, and that makes me feel uncomfortable. So if he needs, and I know that the city has had, he said that they were backed up and couldn't come. I called them and they came for me to inspect it.
Okay. So I don't know why neither of you want to answer my question.
As I don't have a problem with him coming and doing his repairs, if that's what.
So what day can he come in?
Whatever. I mean, he can give me a day. He's all over like we've done this before, and it's like, you have to ask him. I will make it.
Okay, so what day do you want to go do the repairs?
I cannot say that it's gonna be all in one day. There are several.
Okay, so what day do you want to start doing the repairs?
I will start later this week. I will come in
That
Thursday or Friday. Either that,
Emily, if I said to you, give me a date for a case, would you just give me any date and just an approximation? No? Because that's not what I asked, right? Yeah. So.
all right,
Glad we got it straight, because I was trying to figure out if that's how it worked. Yes, you.
I will do the work next week. Between Monday and Friday, I will,
So what date are you gonna geez, oh Pete? Just,
Monday,
what is Monday, Emily?
The 28th.
28th.
Finally, a date, October 28th. After endless back and forth, the landlord commits to starting repairs. But notice the hesitation. He keeps adding other days, and it won't be one trip. To the judge, that sounds like another moving target. Simpson cleverly exposes it by asking if you had to give a court date, would you be this vague? The courtroom laughs, but the point is deadly serious. Precision matters in law. This moment highlights Simpson's style, sarcastic but surgical. He uses humor to drive home that the landlord's shifting answers won't cut it. Meanwhile, Susie sits back, likely relieved that the judge is pressing him to commit. This is a key turning point. The case is now about enforceable commitments, not vague promises. For the audience, how many of you think the landlord will actually follow through on the 28th? Or is this just more stalling?
but I will also, if I need to be in there other days. There's drywall repair that needs to be done, that cannot be done in one trip. I need to have inspectors, lined up and scheduled to come in for their process. And I don't know what their schedule is and when I can get an inspection for them. It's not a one-day repair to get these things done.
Oh, no, I've seen the pictures. I realized it was gonna be more than a day. So you're gonna go in, start repairs on the 28th. Question mark, right?
Monday, the 28th. I will plan on going in and doing all the repairs I can that day. There will be other issues that still need to be addressed with
You guys.
the building department.
Okay.
Sorry.
But
When are you leaving? That was also a question.
I am leaving as soon as I don't have to come back to court anymore. I mean, can we do it in Zoom in Seattle? I just can't move from there to another spot and then to Seattle. The only reason I'm still here is because this case is still going. And the reason I'm here is
Okay.
seeing the pictures.
So
I mean, is this case going to be done after today? Is it going to be completed, finished?
Judge Simpson voices what everyone is thinking, is this ever going to end? The judge sees the cycle, endless hearings, the same issues resurfacing, and no resolution in sight. Susie's frustration also peaks here. She says she's stuck in town only because the case drags on. The judge is pointed, after today, will this be done? Is less a question than a warning. Simpson doesn't want his courtroom clogged with repeat hearings. This moment exposes how drawn-out landlord-tenant disputes can be, procedural delays, technicalities, and stubbornness on both sides. For the audience, this is the grind of litigation. Justice moves, but often at the pace of molasses. Viewers, do you think the judge should force an end today, or is he right to let the parties sort it out one more time before ruling?
at the rate you guys are going? Really? Okay, so here's what I'm gonna suggest. Can you guys talk to each other civilly? Without me?
I
Don't think so.
certainly think I can.
Your Honor, So, this case resolves itself with possession.
What?
This case resolves itself with possession. Should Ms. Norman have be moving to, or going to Seattle?
Except counsel. You're charging rent. You just told me it was 19,000 that you want from her.
Your Honor, what we want is possession. We haven't claimed, there's been no claim for money judgment.
So you're gonna waive rent?
No.
Okay.
Well, in this case, we're not asking for rent.
Wait,
We-
Your Honor, my client agrees to waive rent.
This is a major turning point. The landlord finally agrees to waive claims for back rent. That's essentially surrender. For weeks, the case hinged on money. Now, it evaporates. Simpson pounces, clarifying, "So you're waiving rent?" "Yes, it's a tactical lock-in." Once said, it's binding. Susie gets breathing room, but don't miss the undertone. The landlord wants possession above all else. It's a trade, no rent money, but Susie must leave. From a legal standpoint, this is smart damage control by the landlord. Possession is enforceable. Rent without compliance is not, but it also signals weakness. Audience question: if you were Susie, would you take this deal and leave peacefully, or dig in knowing the landlord's legal standing is shaky?
Okay, well, would you agree to release the escrow to me so he can get possession? I can go and the case can be done today.
Wow.
As much as I like to be in this courtroom, this is my eighth.
Oh, I liked it until this morning.
What?
Look, here's what we're gonna do. You're waiving rent. You're waiving any claim for monetary damage.
Yeah,
Is that right?
yes.
And when are you gonna leave?
10 days? Or less?
Perfect.
Mr. Kurji said perfect. I'm not trying to stress you out, Judge.
You are not stressing me out.
Okay,
Trust
good,
me.
Good.
Trust me. I got a lot more. I got a lot of
Okay.
other things that stress me out. This is not one of them.
Oh. There's the bright spot.
Okay, so what are we doing? You waived your claim for rent. You're moving when?
10 days or less, and I can take the keys.
So Pete, give me a date. Just give me a date that you're going to leave.
What is the date today? The 22nd? October 31st.
It was the 22nd. It's probably the
October
25th by now.
October 30th.
What? October 30th. Will that work?
October 30th becomes the magic date. After stalling, backtracking, and vague promises, the judge forces a commitment. Susie agrees she'll be out by then. This is where legal drama meets human drama. For Susie, moving isn't simple. She mentions she has 5 people to relocate. Think about that, 5 lives uprooted because of compliance paperwork the landlord failed to maintain. Simpson balances firmness with empathy here. He doesn't sugarcoat it, but he makes sure the deal is clear. Leave by the 30th, waive rent claims, and wrap it up. To viewers, this illustrates the judge's efficiency. He cuts through bickering and lands on enforceable dates. Engagement. Do you think 10 days was fair time for Susie to move, or should she have fought for more breathing room?
That worked, Your Honor.
Do I need to get this repairs done next week? Or that's, can be done after she moves out?
Write up a conditional order of dismissal, waiving all claims for rent money. You can put both case numbers on it because if there's no claims for money, then that would resolve your other case, would it not? Amazing how I do this. Write up a conditional order of dismissal, look it over. She's going to leave on the 30th. And then come back and I'll sign it. All right, I'll pass the matter so you can write that up.
All right, thank you.
Come back and
Today. Oh, no, you guys are not leaving.
in escrow.
What about it?
I'd like to have that.
Okay, if they've waived all claims for money, what do you think happens to escrow?
I don't assume anything. In nursing, we don't assume it. I can't assume it in your courtroom, sir.
This is pure Judge Simpson, sharp, witty, and unflinching. When Susie snaps, "I don't assume anything in your courtroom," Simpson fires back with equal heat. The tension here is electric. Both sides have been sparring for weeks, and the judge's patience is thin. Yet beneath the sarcasm, there's a lesson. Nothing in court is assumed. Everything must be written, agreed, and signed. The courtroom is not about vibes or trust. It's about enforceable language. Simpson reminds everyone that until ink hits paper, no deal is final. For viewers, this is the climax of judicial authority. The judge taking control, channeling frustration into a structured dismissal. Audience, how many of you enjoy Simpson's no-nonsense style, and how many feel he's too sharp with litigants who are already overwhelmed?
As long as it's written on the conditional dismissal, then fine. Can't assume anything. I don't know the law language. I don't know it.
Oh, I'm
Yeah,
aware.
I know. You can
I'm aware.
the 8 times I've been here.
What?
I said, I know you probably gathered that the 8 times I've been here.
It's only been 8? Seems like 50. All right, go out, write that up. Escrow goes back to defendant, plaintiff on the other case, and then we can be done with this.
All right, thank you, Your Honor.
Thank you. Hey, do me a favor. Keep an eye on them because that's going to blow up. I don't know what's going to happen, but it's going to blow up. All right. Okay, this is fine, except that, how much is the water bill?
I know that it's at least 1,100. The last bill that came
It
out.
was 1,500. It was 1,500 when I walked in.
It's 1,100. It's 1,100. And because of the leaks in the house, I'm having that evaluated. But that's how much it is now because they bill every 3 months.
So when's the next billing?
Well, the billing is, I'm not sure if it's set up on quarterly. I believe it is. I'm not exactly sure.
You got the bill and came over and waved it in my face. You should know.
Was that really necessary? Was it necessary?
No,
Was it necessary?
no.
Then don't let it happen again. Okay. You're agreeing to pay the water bill, whatever it is, to the 31st. You can call the water company and you can get it so that the 31st is a date they can tell you how much you owe. Okay?
Okay, Your Honor. Thank you.
So here's what I'm going to do. I will release the escrow to the defendant, but I really don't want you guys back. So I'm going to hold the escrow until I can get a final water bill.
The escrow battle is fascinating. Judge Simpson decides the escrow money over $3,000 will be split, but not until the final water bill is tallied. Why? Because unpaid water charges become liens on the property. That's a subtle but crucial point in landlord-tenant law. Simpson won't let funds move until debts tied to the property are settled. For Susie, that's both relief and frustration. Relief because money is coming back, frustration because she needs it to move. For the landlord, it ensures he doesn't get stuck with unpaid utility bills. This is legal chess. The escrow isn't just money, it's leverage. Simpson uses it to force compliance and accountability. Question for you: should escrow always be this tightly controlled, or should tenants get faster access to move out funds?
Then pay the water bill to the plaintiff. The balance will be returned to the defendant.
Thank you, Your Honor.
I don't understand.
Okay, let's say the water bill comes up by the end of this month being 1,500. Okay, that's what I heard. All right. Let's say it's 1,500. They will get to me that final water bill. Right. And then what I would do is I would send them the 1,500 as though you're paying it, and then release the rest of the escrow to you.
Okay, we have to wait till the 30th. Yep. I have to
Till
get
you
the bill
move.
for the 31st.
Pardon?
I have to get the bill through the 31st or through now. And you just take the money out of that and pay that bill.
You need a reading as of the 31st. Whatever that reading is, the water company will go through, they'll figure out what's owed through the 31st of October. That amount will be deducted from the escrow and will go to the plaintiff, right, to Mr. Stanford. The remaining part of that escrow will then be paid to you. Anybody unclear as to that?
Makes sense to me.
I'm clear, but
But what?
I don't think they just, never mind.
You don't think they just what?
Never mind. They must read it at the building.
We'll call them.
Get a final reading as of the 31st. Otherwise, what's going to happen is I'm going to just wait till the next bill comes out in 2 months. I'll prorate it myself.
Here, we'll get you that water.
I'm just going to add to this that the escrow is to be released after presentation, final water bill. So what I'm going to do, folks, is this. This resolves this case. And what I have here is that plaintiff is waiving any claim for rent. Defendant agrees to return possession to the plaintiff on or before October 31st, 2024. Escrows to be released to the defendant. The defendant, however, agrees to pay the water bill through October 31st, 2024. I've added language that escrows will be released after presentation of final water bill to the court. Does everybody understand that?
Yes, but I could use that escrow for moving.
Yes.
I have 5 people to move.
Okay, so you don't want to agree to that? When is the water bill going to be paid then?
Pay it out of the escrow, that'll, 1058. That'll take care of what's due now, that was due on the 2nd.
Then what do we do with the period from that 2nd through the 31st? You realize, ma'am, that water bill becomes a lien on the premises if it's not paid.
I do.
Okay, so it's somehow or another, it's going to need to be paid.
That last portion I will pay. That last portion from the 2nd to the 31st.
You guys figure out what you want to do because the money's there. I've told them to get a bill. You don't want to do it that way. I can't sign this conditional order dismissal. I don't know why you two can't come to some type of rational understanding of how this is going to be done. If you guys want to sit in here all day and fight it out, fight it out. Court's in recess. You guys work out. Let's try it again for the 3rd time. Stanford versus Norman.
Ms. Norman and I have, we've come to a clarification on the consent order. Plaintiff is going to waive any claim to rent. Defendant agrees to return possession on or before the 31st of October, 2024. Plaintiff and defendant agreed to split the $3,300 escrow in the following way. Plaintiff is to receive $1,500, the defendant receive $1,800.
Finally, resolution takes shape. The escrow is divided $1,500 to the landlord, $1,800 to Susie. Both walk away with something. Notice the math. The split reflects not just fairness, but practical resolution. Simpson ensures both sides feel they got at least part of what they wanted. But Susie's comment, "I feel like I'll be back," foreshadows future disputes. And she's probably right. Cases like this rarely die cleanly. There's often fallout, damages, repairs, new bills. For the moment though, the judge brings finality. It's a reminder that courtrooms rarely produce perfect winners. They produce settlements everyone can live with, even if grudgingly.
Plaintiff gets 1,500.
Defendant shall receive $1,800.
Did you write that up? Ms. Norman, is this your understanding?
Yes, it is.
Do you have any questions regarding anything contained on this conditional order dismissal?
I don't have any questions regarding that. I do feel like I'll be back to see you though. For
Why?
damages, but
For damages,
yeah. But
underlying which in,
I understand that and I signed it and there it is.
well, but that's going to get rid of this case also. That's why I had you put both case numbers on. I was trying to resolve all these cases. So is that your understanding, ma'am?
Yes.
Just going to add a provision on here that case ending in 3728 is dismissed. All right, you do have 3 business days to think about this. If you have if there's any legal reason, any misunderstanding, any non-assertion of rights in this matter, you'd have to file a motion with the court. That doesn't mean that I would grant the motion. However, you do have those 3 business days. You understand that, ma'am?
I do.
Case ending in 2445 is conditionally dismissed, and I've signed the order. You can pick up a copy up front. The other matter is dismissed. Thank you.
Thank you, Your Honor. Good morning.
And with that, Judge Simpson closes the book on this messy landlord-tenant saga. Key takeaways. 1. Without a valid certificate of compliance, rent demands collapse. 2. Escrow funds are not just money, they're leverage, carefully allocated to cover debts and balance equities. 3. A judge's patience is finite. Simpson's sharp questioning, sarcastic remarks, and relentless focus on compliance left the landlord cornered and forced to waive rent claims. Susie walks away with cash and time to move, but not without stress and uncertainty. The broader lesson here in court, paperwork and timing outweigh bluster every time. If you're a landlord, stay compliant. If you're a tenant, know your rights. And if you're Judge Simpson, you keep the courtroom moving, no matter how tangled the case gets. If you found this case as shocking as we did, hit like, drop your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.